On April 7, 2025, Jamie Marie Jerkowski was sentenced in a Michigan district court on domestic violence charges, with conditions requiring substance abuse evaluation and follow-up treatment. 11 months later, on March 11, 2026, she returns to court for a pre-failure to comply hearing after repeatedly failing to initiate court-ordered moral recognition therapy, MRT, and individual counseling sessions. Simultaneously, her mother and alleged victim, Donna Holmstrom, has filed a motion to rescind the no-contact order that has kept mother and daughter apart for nearly 2 years. The hearing will test the court's authority to enforce sentencing conditions against a defendant who claims fundamental misunderstanding of her obligations while weighing a victim's right to restore family contact against concerns about untreated behavioral issues.
And Your Honor, I don't know if Ms. Langley's ready yet on Mr. Jerkowski, but the victim is present for that matter in regards to the motion to drop the no contact order.
Is that Ms. Jerkowski or Mr.?
It's Ms. Jerkowski.
Jamie Marie Jerkowski, she's not here?
She's on Zoom.
I'm right here.
Good morning, Ms. Jerkowski.
Hi.
This case is before court for a pre-failure to come for an NCO motion of, is that Donna Holmstrom?
Yes.
Okay.
And Your Honor, is Ms. Jerkowski able to turn her video on so we can see her?
Ms. Jerkowski, are you able to turn on your video?
No.
Ms. Jerkowski, I have a bad connection. I think you're cutting off and on. Maybe you should try to log off and switch back, log back in. There you go.
Probably I have to go closer to the door.
Okay. Whatever it takes to rectify the situation. In any case, what issue do you want to address first, Ms. Langley, the FTC prelim or NCO?
Well, it might make sense to address the FTC first.
Okay, I agree. So as to pre-failure to comply, Ms. Eddy, what is the issue? Is that the compliance report?
No, Your Honor, it's the fact that Ms. Jerkowski hasn't started treatment. So she was sentenced back on April 7th of last year. She was initially ordered to get the substance evaluation by June 7th. She didn't get it done in time. She was given an extension till July 7th. I believe the one that she did file was from August 9th, 2025. I think I got filed a couple times, but essentially the evaluation said that she did need treatment, and it's now been 7 months since the evaluation was turned in, and there's no indication that she started treatment.
The prosecutor established that Jerkowski has failed for 7 months to begin court-ordered substance abuse treatment, despite receiving multiple extensions and completing only the initial evaluation. The court is now considering whether to find a violation of sentencing conditions. Under Michigan Compiled Laws Section 771.3, courts have broad authority to impose reasonable conditions of probation, including substance abuse treatment and counseling, with violation of these conditions subjecting defendants to revocation and imprisonment. The statute permits courts to require defendants to participate in a substance abuse treatment program and to submit to periodic substance abuse testing as mandatory conditions. Additionally, Michigan Court Rule 6.445 governs probation violation proceedings, distinguishing between pre-failure to comply hearings, which allow early judicial intervention before full violation, and formal violation hearings that can result in revocation and incarceration. Here, the court utilized the pre-failure to comply mechanism under Rule 6.445 to address Jerkowski's non-compliance before it escalated to warrant issuance or arrest. The prosecutor's detailed timeline, documenting the April 2025 sentencing, the June and July 2025 deadline extensions, and the August 2025 evaluation, establishes the record necessary for a finding of violation under Section 771.3. The court's decision to hold this hearing rather than immediately issuing a warrant demonstrates the procedural flexibility designed to encourage compliance through judicial oversight rather than punitive measures. The pre-failure to comply process represents a critical intervention point that can prevent defendants from spiraling into more serious violations while preserving judicial resources. For viewers, this illustrates how sentencing conditions create ongoing obligations that extend far beyond the initial hearing and how courts balance encouragement with enforcement when defendants struggle with compliance.
I note when we last appeared on this matter in front of Pro Tem Laconin, the court said that he would give her one more continuance to get the proof in, but the defendant said at that time she had not done the classes. And we're here again, and she still hasn't done the classes. So it's for the failure to complete the substance abuse treatment. And I note that we are now 11 months after her sentencing date. So I asked the court to find the violation committed, and that we proceed to sentencing. The court makes that finding.
Before I do that, let me ask Ms. Langley. Ms. Langley, has Ms. Jarkowski completed? I see that there is a evaluation in this which recommends MRT and individual sessions. Where is she at on those?
I'm not quite clear. I've talked to her a number of times recently, and I'm afraid, Your Honor, what she's telling me isn't making much sense, even in terms of reality. So I don't know. I don't know.
May I ask her directly, Ms. Langley?
Yes, please.
Ms. Jarkowski, you were recommended to engage in what they call a moral recognition treatment in individual sessions, MRT. Are you engaged in that? Okay, and why not?
Well, on my evaluation, there wasn't any time, and I agreed to an assessment. I didn't agree to go to treatment. So if my lawyer thinks that I'm not talking to her in reality, then I don't know what to say. Can I ask
No,
for another attorney? I'm not in agreement with any of it. None of it was discussed. The UAs I have to pay for. I don't have a job. I'm waiting for Social Security. Let's see, what else? That's pretty much it. I mean,
So let me stop you for a second, Ms. Jarkowski. You did not need to agree. The court ordered that you complete a evaluation and then follow through with any recommendations. And those you completed.
no,
the
actually,
evaluation.
it was a plea bargain because I got a harassment, and they dropped harassment. They dismissed it, and if I agreed to an assessment, so I agreed to an assessment.
The court sentenced you with an agreed assessment and follow up with any recommendations from that assessment. The recommendation from that assessment was that you engage in MRT and individual sessions. And you're going to have to do that.
Jarkowski directly challenged the court's authority, claiming her plea agreement only required an assessment, not treatment, while simultaneously requesting new counsel and citing financial inability to pay for required services. The judge corrected her misunderstanding about the binding nature of court-ordered conditions. Under Michigan Court Rule 632, plea agreements are binding contracts between prosecution and defense, but sentencing remains within the court's independent discretion. The Supreme Court's decision in Bordenkircher v. Hayes, 434 U.S. 357, 1978, established that prosecutors may condition plea offers on specific sentencing recommendations, but courts retain ultimate authority to accept or reject agreements and to impose lawful conditions of probation. Furthermore, Bearden v. Georgia, 461 U.S. 66, 1983, held that courts cannot automatically revoke probation for failure to pay fines or restitution without first determining whether the defendant made sufficient bona fide efforts to pay or that alternative forms of punishment were inadequate, though this protection does not extend to willful noncompliance with treatment conditions. Jarkowski's confusion illustrates a common defendant misconception that agreed-upon plea terms limit judicial authority at sentencing. Here, even if the prosecution dismissed harassment charges in exchange for Jarkowski's guilty plea, the court's imposition of evaluation and follow-up treatment under Section 771.3 was an independent exercise of sentencing discretion, not a contractual obligation requiring her consent. Her financial hardship claim regarding urinalysis costs, while potentially relevant to ability to pay determinations under Bearden, does not excuse her failure to engage in MRT and counseling services typically available through sliding scale or court-funded providers. This exchange demonstrates the critical distinction between prosecutorial concessions in plea bargaining and judicial authority at sentencing. Defendants who misunderstand this boundary risk non-compliance with enforceable conditions, leading to incarceration. For legal education, it highlights why defense counsel must ensure clients understand that agreed dispositions still subject them to the court's full sentencing authority.
Okay, well, for the last 4 times I've been to court, I've had assessment. This last time I had to turn it in, to agree to something, I can't pay for it. I don't know what else to say. I can't afford to pay for the UAs. My medical is not going to pay for it. And are you going to pay for it? I mean, who's going to pay for it?
Ms.
I'm sitting on a
Langley?
$40,000 child support bill.
Let me ask turn to Ms.
Just
Langley.
saying.
Ms. Langley, at this point, since the sentencing occurred and then she had been given additional time to engage, I know that we are on a pre-failure to comply, not a fact finding, but I am convinced that there has been a violation and Ms. Jarkowski is not engaged in MRT, does not wish to engage in MRT or any individual sessions based on her financial hardships, or for whatever reason, she understood that the assessment was the only thing required. Obviously incorrect understanding, but with that, I think there's sufficient basis to find that there is a violation. So we'll remove this case from a pre-failure to comply and move towards sanctions. Are you prepared to address the sanctions right now?
I really would request maybe we set them over. I said, she's telling the court financial reasons today. She told me some other things the other day that I'm not gonna, talk about on a public video. But I'd like some more time to talk with her and see if there's any, I don't know, like what this court needs to know in terms of sanctions.
Before I grant your request to continue the sanction in this case, let me address the NCO motion first. And Miss Donna Holmstrom, is that your name?
Holmstrom,
Holmstrom. What's your relationship with Miss Jarkowski?
my daughter.
She's your daughter. All right. So in your motion you have filed, all you have done is signed that the NCO should be rescinded, but there's no explanation or reason why.
Well, because I feel safe around her, and I've been in and out of the.
And what is the city's position regarding NCO?
Your Honor, while I'm concerned about Mr. Kelsey's
I feel safe.
decision to not do treatment, I do have some concerns for her mother, but I understand Ms. Holstrom is feeling perhaps medically fragile, and I'm not going to stand in the way of that if she chooses to have contact with her daughter under the facts of this case.
The judge found a violation of sentencing conditions but deferred immediate sanctions at the defense attorney's request, then pivoted to address the victim's motion to rescind the no-contact order. The prosecutor, despite concerns about Jarkowski's untreated behavior, deferred to the victim's autonomy given her medical fragility. Under Michigan compiled laws section 764.15b, no-contact orders in domestic violence cases may be modified or rescinded upon motion by the protected party, though courts retain discretion to deny such requests when safety concerns persist. The statute requires judicial findings that rescission would not endanger the victim or public safety. This aligns with the broader principle from People v. Cunningham, 201 Mitch, App. 376, 1993, that victim preferences are relevant but not dispositive in protective order proceedings, as courts must independently assess risk factors, including defendant compliance with treatment, pattern of violence, and victim vulnerability. The judge's decision to hear Holmstrom's motion before finalizing sanctions demonstrates procedural prioritization of victim autonomy within safety constraints. The prosecutor's qualified acquiescence, acknowledging concerns while respecting Holmstrom's medical circumstances, reflects the balancing act required under Section 764.15b. The court's inquiry into Holmstrom's reasoning, rather than rubber stamping her request, satisfies the statutory obligation to evaluate whether rescission poses unacceptable risk despite victim consent. No-contact orders fundamentally restrict protected persons' liberty as well as defendants, preventing family reconciliation even when both parties desire contact. This exchange illustrates how Michigan law attempts to balance victim self-determination against paternalistic safety concerns, particularly when defendants demonstrate non-compliance with treatment designed to reduce recidivism risk.
Thank you. So, Ms. Holmstrom, do you think your daughter needs she will someday maybe engage in treatment on her own? Okay, and where does she live? How far does she live from
She
you?
lives there.
And Ms. Jarkowski, are you also requesting that this no contact order be lifted?
Didn't put it in place. I don't know
I mean,
anything of those things.
Do you
Of course I want to see my mom.
you want to see your mom?
Of course. Why wouldn't I want to? It's been almost
Do
2
you-
years.
Do you agree and you have promised that you will not be violent in the household when you see her?
Yes.
Okay. And Ms. Holmstrom, if anything happens, all right, I'll grant the request, the motion to rescind no contact order by Ms. Holmstrom, and she is the alleged victim in this case. And I will expect a rescission order in that case. And as it relates to sanction hearing, Ms. Langley, does
I
she have
don't,
a job?
I don't know, Your Honor. Jamie, are you working?
No.
Ms. Cherkowski, let me explain this. Now that you have been found in violation of your required sentencing condition to engage in MRT and individual session, the other alternative the court can employ is sanction you, and that could be up to jail time. So what I will do today is find the violation and not impose any sanctions at this point. Hang on, let me finish. I'm not imposing any sanctions. I am finding but however, I'm not lifting the conditions of previously imposed sentence, which include continuing with MRT and individual session. What I will do is set this case for a compliance, and I'll allow you time to engage in MRT and individual session, come back in 60 days. And if you are not in compliance, the city can request sanctions. Holmstrom, I am signing off on this rescission order. If you want a copy, we can provide you one right now.
Your Honor, it's gonna take me a few minutes to prepare that unless for some reason. Oh, I do remember. And Your Honor, what date was that hearing gonna be?
I was gonna do May 11th.
So, Ms. Jarkowski, I'll sign off on this order that requires you to come back to court on May 11th at 10 a.m. To show that you're in compliance with your MRT and individual session requirements. Compliance, there might be a sanction issue.
To clarify for the victim's sake, Your Honor, so that they're allowed to have the orders effective today.
Thank you.
The court granted Donna Holmstrom's motion to rescind the no-contact order, permitting mother and daughter to resume contact after nearly 2 years of court-mandated separation. Simultaneously, Judge found Jarkowski in violation of her sentencing conditions for failure to complete MRT and individual counseling, but declined to impose immediate jail sanctions. Instead, the court established a 60-day compliance deadline with a follow-up hearing scheduled for May 11, 2026, giving Jarkowski a final opportunity to engage in treatment before facing potential incarceration. The dual resolution balanced victim autonomy with continued judicial oversight of defendant rehabilitation. This hearing illuminates the interconnected machinery of criminal sentencing, how plea agreements trigger probationary conditions, how pre-failure mechanisms provide early intervention opportunities, how victim preferences interact with protective orders, and how courts wield graduated sanctions to encourage compliance. The case demonstrates that sentencing does not conclude at the pronouncement of judgment. It creates an ongoing relationship between defendant and court, mediated through conditions that carry real enforcement consequences. Jarkowski's journey from April 2025 sentencing through multiple continuances to this March 2026 violation hearing exemplifies how quickly non-compliance compounds, transforming manageable obligations into incarceration risk. For viewers, the critical takeaway is that court-ordered conditions are not suggestions subject to personal interpretation. They are enforceable legal obligations backed by the state's power to deprive liberty. The court's decision to defer sanctions while maintaining conditions reflects a pragmatic recognition that treatment noncompliance often stems from practical barriers, financial, psychological, or logistical, rather than willful defiance. Yet the firm's 60-day deadline with explicit jail warning establishes that judicial patience has limits. This case ultimately demonstrates how modern criminal courts attempt to serve multiple masters: public safety through treatment and monitoring, victim autonomy through protective order modification, and defendant rehabilitation through structured opportunity rather than immediate punishment. If you're facing criminal charges or struggling with court-ordered conditions, consult with a qualified defense attorney immediately. Misunderstandings about your obligations, like Jerkowski's confusion about assessment versus treatment, can have serious consequences. For those interested in Michigan's probation system, review MCL Section 771(3) and Michigan Court Rule 6.445 to understand your rights and responsibilities. Victims seeking to modify protective orders should contact their local prosecutor's Victim Services Unit for guidance on the legal process. Subscribe for more educational court content that breaks down real legal proceedings into understandable principles.